Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about elections. Cases that should have gone to the Supreme Court of Canada, but didn't. Joseph Anglin was unsuccessful in the Alberta provincial election in 2015. As a result of some reasons that we don't really need to get into here, he sued the chief electoral officer, alleging that things had gone wrong in the election and it was all the chief electoral officer's fault. He also sued and advanced a claim under the Proceedings Against the Crown Act, essentially arguing that the chief electoral officer was an employee or an agent of the Crown, and in acting as their role as chief electoral officer, they were covered by the Crown liability policy, and that it was ultimately the Crown who was going to have to pay the claim against the chief electoral officer if Mr. Anglin was successful. The court dismissed the claim on the basis of the fact that the chief electoral officer is an employee of the legislature and not an employee of the Crown, and that there's a difference between the executive branch and the legislative side of the state. There was a dissenting Court of Appeal judge who felt that the entire point behind the Crown Proceedings Act was to ensure that all of these agents of the Crown, regardless of legislative or executive, were all covered under the same procedure. And this was an important question that the Supreme Court of Canada ought to have heard. First of all, there was a dissenting judge at the Court of Appeal who felt differently, so that alone tells you how uncertain the law is in this area. It's also something that is really important, because for people who are advancing these types of claims, especially because we know that there is likely other litigation out there surrounding the election in 2015 in Alberta, as well as we see litigation happening in south of the border in response to the outcome of the 2020 presidential election. Aren't these issues that should be determined? Who do you sue and how do you sue them? And if the chief electoral officer is an employee of the legislature and is not protected by the Claims Against the Crown Act, does that not make people less willing potentially to step up to take on that role because of the potential that they could be sued and not covered by legislation that allows the Crown to step in and deal with the claim and to pay out the claim potentially if it's advanced successfully against them? That exposes people who hold these important offices in our democracy to greater risk and less coverage, and it makes more people less willing to want to take those important offices. We shouldn't have that, and governments function as a whole. Even though there are different branches of government, ultimately, they all function as a collective unit. So shouldn't the law that applies to one apply to all of them so that it's easier when these lawsuits take place to have certainty about who to sue and what to sue them for and who's going to respond on behalf of all of this? This is an important issue that the Supreme Court of Canada could have addressed and should have addressed to provide greater certainty for these extremely rare but extremely important types of lawsuits that happen in our country. Hopefully another case makes it to the Supreme Court of Canada so that we have more clarity about whether the Crown Proceedings Act does apply to people who hold positions that relate to actions of the legislature. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.